100%.
Okay, we're going to start. Good evening, everybody, and welcome to our Thursday evening seminar. Today is the penultimate in the Adjudication Matters series for this year on the topic of payment adjudication. And as always on this series, we are joined by Mohammed Haque, who is consultant barrister, adjudicator and quantum expert. It's a very long title to fit on a business card there. As always, if you have any questions for Mohammed, please feel free to utilise the Q&A or chat facility in your bottom toolbar, and he will answer as many of those as possible at the end. Alternatively, if there's something you'd like to speak to him about on this topic, but you don't wish to ask in an open forum, you can see on the screen there his email address, mohammed.haque@fletcherday.co.uk. He will be delighted to answer any questions for you. Okay, without any further ado.
Right. Thank you, Julie, and thanks everyone who's joining me this penultimate episode of the webinar, which I've been running since the beginning of the year, which is about adjudication. Adjudication matters, and I try to explain in different ways the pros and cons of it. And these are the last or final two episodes today, one, and then 2nd of December, I'll have another one where I will try to show you making a claim in an adjudication, payment adjudication today. And then on 2nd of December, I will present one for a claim of money. And just to give you an advance idea, I'll be doing for the claiming of the money, I'll be doing a loss and expense, not a loss and expense, an extension of time claim. I will try to demonstrate that with you. But today is for the payment adjudication, and in my normal style, I will start by asking the question, what is it? Well, payment adjudication is an ADR process. And those of you who are not familiar with what an ADR is an alternative dispute resolution. Let's not be bogged down with why why is A and why it's alternative, not additional, and this and that. It's just a dispute resolution process, and it's in the international side. It's under FIDIC and it's contractual. But in our country here in England and Wales, it's a creation, especially for the construction contracts, by an act called Housing Grants, Construction and Regeneration Act of 1996. And I will time to time refer to this as the Act. And the Act not only provides adjudication, a lot of time we talk about the drawbacks of adjudication, this, that, the other, but we forget that the fundamental, the primary aim was to provide for cash flow or guarantee cash flow in construction projects for the contractors, because that's vitally important. And so there were provisions made within the Act which makes it obligatory to make stage or interim or periodic payments, or payments in installments, not at one go at the end of the whole contract. So this is something which was already there into the contracts. In many contracts, FIDIC always been doing it for ages. Internationally and within the country as well, we were doing it in major contracts as part of express terms. But what was not there was making it mandatory to follow, and ability for the aggrieved party who hasn't received payment to suspend works. So primarily the Act has made it overriding, so you cannot exclude it. And thirdly, and it's not normally not in contracts where it's a consumer contract, and for the extension or building of a residential premises where the employer is going to use it as their primary occupation. It's not for those contracts, but normally in business contracts you cannot avoid them, and every contract will be a mandatory interim payment regime. Only exception is if it's like for a short duration of period, and it's specified within the contract that this is going to be for a very short period. The specific number of days, you can go to the act and find out. That's not my focus here, so I'm not explaining that any further. Now, what the act says in its payment provisions between 109 and 16, that every construction contract must include provisions for interim payments, installment payments, stage payments, and also another fundamental breakthrough, which has been redone in 2009 Act, or amendment of the 2009 amendment of the Act, wherein through sections 110A, B, and all of these, the Act requires either the paying party or the payer, the paying party or the receiving party to periodically issue a notice stating how much the payer is obligated to pay or the payee is entitled to receive. And that's a mandatory thing. It's the Act has given freedom to the parties that in what in what intervals parties gonna take stage payments or payments in installment. That's absolutely their choice. But what they cannot do is avoid issuing the payment notices. Okay, that's mandatory. Okay, that's mandatory. And the payment notice is the key document in which the entitlement and the obligations are spelled out. So that's a key feature. That's an obligation on the payer, or if the contract says on the payee to issue to get his entitlement. And that's a fundamental breakthrough in the whole system. And if a party defaults, there are provisions for that as well. So in other words, the Act guarantees that payments are made in installment. How many installments is a matter of the agreement of the parties. The second thing to remember is at each cycle of installment or the end, there has to be a date called a due date. And within 5 days of those due dates, the payer or someone on their behalf or the payee will be required to issue a notice, okay, that this much is the entitlement of the payee. And that particular notice must also be given in a particular way. And if it's given, then the amount shown on that face of that notice is the amount payable, okay? And if that's not given, then that's a default. And I will get to the next slide and explain what will happen if there is a default by the party who's supposed to issue a notice. Now, the general rule, as stated in 111, that the employer must pay the notified sum. Notified sums are sums which are within the payment notice, but there could be some occasions where the notified sums are kind of deemed as, in a document which is deemed as a payment notice, but one way or the other, it's within the sometimes called payment certificate, but the latest is payment notice from the Act. So that's the sum which is given there. And the employer must pay the notified sum. It cannot avoid it. Must pay the notified sum, or the paying party must pay the notified sum, whatever way you want to say this. And because there are contractors and subcontractors, in that case the contractor is the payer, must pay the notified sum, except that they can issue a valid notice of intention to pay less than the notified sum. So in other words, there is a second notice possible, that even though for some reason there is a sum which is notified as is considered as a notified sum, the employer can still, or the payer can still avoid paying that, provided they issue a valid notice of intention to pay less than the notified sum. Now, going back to the payment provisions again, I just summarized it already, that the Act granted rights to payments by installment, staged, or other periodic payment, meaning that stage payment is the one where you set milestones. Like if you complete the ground work, you get this much. You complete the, the flows, you get this much. So it could be like staged, or the installment could be periodic, regardless of whatever is achieved on every first day of the month, if that's a business day or a working day, you will a payment will be due to you, to the contractor by the employer. It's stated, and as I said, the notice mandatory, doesn't matter. Even if you say that I don't need to give a notice, it doesn't make any difference. You'll have to give a notice, and the notices are for every single payment under the contract. Exception that I said, if only the contract is of short duration, and that's been defined in the Act as well. Now, for every payment under the construction contract, a compulsory notice showing how much payment is due and showing the basis of its calculation. So two things needs to be included into the notice. One is an amount been specified, that how much payment is due, and the other thing is the basis on which that has been calculated. Now, there is very least or almost no case laws to show what does this mean, the basis of its calculation. A mere calculation or an explanation may be good enough. However, we have judicial kind of guidance that it has to be something from which one can understand the basis of the entitlement of this, the amount specified on the notice. Okay. Now, one thing to remember, and this is to do with, I'm doing another webinar, I think on 24th of this month, where I'm doing on payment, I want my payment type is the title. And also, in our next session, I'll be doing adjudication and drafting of adjudication regarding a claim of money. In all these, one thing has to be in your mind very seriously: every and any payment under a construction contract. Now, let's just take stock here, prepare a list of what are the different payments one's normally entitled under a construction contract. First, that comes to mind is the advance payment, or sometimes we used to call it in Asia mobilization payment. It's a bit rare these days, at least in England and Wales, we don't get that. But that's the first payment normally, either even before mobilization or at the time of mobilization, just after the mobilization. Sometimes contractors, considering the fact that contractors are very lean on their cash, so it's in the interest of both the parties that an amount is handed over to them so that they can buy materials and organize a mobilization, because mostly these are on hired things, and the project starts and gains speed in no time, at a proper pace, proceeds. So that's how it is organized. But these days, I don't see much of advance payment or mobilization fee in normally in construction context in England and Wales. That's where I practice. I'm not even Welsh. I really practice in London and Southeast. So that's the most of my experience coming from for the last 7-8 years. So that's one payment. I just wanted to mention this. And then, of course, the periodic or a stage or installment or interim, whatever name you want to give, is another, comes after each stage completion or after end of month or the beginning of each month or fortnightly, quarterly, monthly, weekly, whatever that is. So that's one type. And then come, of course, paying back the retention. And it's again a norm that, you have your retentions been paid half at the time of practical completion or a percentage at the time of practical completion. And then after the defect liability period, you get back everything or it's been deducted, whatever, whatever may be the case. Now, the payment, when you say during the interim installment and all these, can be one of the two again, or three types. One is for, obviously, the for the for the measured works or the works for which a price has been fixed and the performance of that has been done. So sometimes it's a wide range mistake, I would say, among the QSS, that when there is a measured work price lump sum agreed at the beginning of the contract, and then we have, let's say, a contract of 5 months duration. What the QSs do when they sort of try to find out the entitlement for the month, many a times they just divided by 5. So the whole thing is, let's say, £100,000. So they will just give you £20,000, and which includes, of course, prelims as well. That's not the right thing to do. Keep in your mind that you got to sort of do the works that was planned and done. Okay, so that's the right way of doing it. That the amount, and then the prelim not only to be divided by weeks or months, it should be matching the value of the contract that has been performed within the period of time for which you are making the payment. That's one thing to remember, because otherwise you'll be ending up of overpayment, and especially of the prelims, and it creates problem. Then the next thing to think of is, of course, in interim payments and of course in the final payments, the instructions of changes, okay, either through the compensation events if it's an NAC, or I think FIDIC used to call it engineer certificate, or if it's a JCT, through a change instruction by the contractor or the contract administrator, architect, or employer's agent. And then, of course, a completed valuation, agreed basis or whatever basis you have a valuation there. So whatever for the month falls due on those counts, these are all under every payment. That's what I'm trying to say. So you've got to keep in your mind the notices of every payment when you are actually compiling a payment notice. And then say, for instance, JCT, loss and expense is separately conducted. So that's also a payment under the contract. And finally, you like it or not, if there is a termination, so there is a post-termination payment. So these are different things: retention, post-termination, variation, loss and expense. Whether you agree through the compensation event or a variation, valuation, quotation, is a different thing. But all these comes under, and then the right of the employer is to withdraw the liquidated damages. Okay, so whatever the payment is, you got to enforce it through one of the notices. Okay, and for every payment under the contract, notice is the mechanism, right? So that's why these two notices are so vital. And as I said, and I'm repeating it, that if the party who is obliged to issue a notice fail to issue it, then that party is treated as in default, and the payee in that case is allowed to issue a notice in default. Okay, why do you not, if the contract says the payee is to specify, okay, payee is to specify within 5 days of a payment installment cycle, the entitlement, and if he fails, Why there isn't anyone needed for a notice in default from the other side? Because payer is not going to do that. It's your entitlement. If you have missed it, that's your problem. Rather, payers normally say in situations like this that if you fail to send it like that, we'll not even consider that for till the next month. So there isn't, I mean, caveat pays. There isn't anything like a payee a default notice. There's a payer's default notice, meaning that if the payer defaults, then the payee may come forward and say, okay, you have defaulted. You are under the obligation to do the evaluation. You have defaulted. Now, you have no chance, but I will now specify. The Act allows that. Okay. So the same thing, they have to make it validly expressing the amount due, specifying the amount due on the day they're sending the notice, and also the basis of the calculation, right? That's it. That's a default notice. Now, the sum in a payer or payee default, payer notice, or a payee default or deemed default notice is called a notified sum. So when is the payee notice is default? Now, sorry, deemed default notice. When is that? Now, if the contract allows or permits an application from, it's not an obligation, it's a contract allows or permits to make an application, payee, if he's allowed to make an application and he validly make one, then you don't need to issue a second notice of default. In the absence of evaluation from the payer, it will automatically become or will be deemed as the default notice from the payee. So again, unless the payer issues a notice to pay less than the notified sum, is bound to pay the notified sum. Okay, so notices when to issue. As I said repeatedly, the payment notice must be issued 5 days after the due date. So I repeat, every single contract must include the entitlement of the contractor or entitlement of every payment under the contract, dates which are due date. And as payments are allowed in installments or interim payments are allowed, so for every interim payment, there has to be a date on which it's due, but it's not the date on which it's paid. Only within 5 days of the due date, the payer needs to, or a person on his or her behalf, employed, or if the contract says, okay, the quantity surveyor will give it, or the contract administrator will give it, that person, a third party, must issue the notice within 5 days. Right? You remember this, 5 days. Doesn't matter what your contract says. The law says you must specify in your contract the list of dates. One of that is due date, on which every single payment says this is when this payment is due, that is when that payment is due. And within 5 days of that due date, the payer or a person on behalf or a payee will be given the right to issue a notice, and it's a duty as well, if it's on the payer's shoulder or somebody he appointed, to issue a notice in which he specifies how much he's going to pay and the basis on which he arrived to that figure. Now, once that notified sum is ascertained, or as we said, if there is a default notice by the payee because the payer failed to issue one, so the Act allows him to give them a default notice by the payee, then that sum becomes notified sum. Or if the contract allows an application by the contractor, then once a contractor made an application validly, in that case, if there isn't any payment notice done by the employer, the application sum will become the notified sum. So that sum becomes notified, and that has to be paid, that has to be paid by the final date of payment. Now, say for instance, the contract says this is the final date of payment for an interim payment, but contract also requires the payer to issue a notice. The payer defaulted. Now, the if the payee delays in issuing the default notice, in that case, the final date of payment will also be delayed by as many days the payee delayed his own default notice. Okay, who will issue? As I say, the payer, the payee, or any third party the contract says will be issuing those notices. And if in the contract it says something which is not compliant with the above provisions, the part 2 of the scheme will come in aid and will assist us to fill in the gaps. Okay, so there is a default position. That's a contract provision incorporating correctly these requirements. If in any respect a party fails, for example, they do not spell out what will happen after termination. Scheme says again that for such a thing, any payment under the contract, the due date will be the day on which it has been made or day after which, a particular number of days after which, let's say 1 month after which the works were completed. So these sort of things you cannot escape. If you miss one, automatically the scheme will come forward and part 2 will help us. Okay. So what are different provisions of the scheme part 2? Again, it provides for, because scheme part 2 doesn't know where would you fail in your contract. So there is a failure, then interim, final, and other payments or any payments for any payments, provisions have been made. They explain what the due date is going to be in such a situation. You know, for interim payments, it's a monthly cycle, 28 days. For final payment, it's after 90 days of completion of the works. For any other payment, it's 30 days after completion of the work. So that includes termination, of course. So also variations as well. So if you haven't spelled out what's going to happen in a situation like a variation, you know, I mean, I just had an adjudication 3-4 months ago where the legal representative must be a non-construction lawyer, and he argued that we haven't provided for any payment dates of the variations. Fair enough. I mean, the scheme will come in support, and it's as long as it's a payment under the contract, you'll be able to make it or include in your application after 30 days of your completion of that item of works as agreed under the variation under the change instruction. So the scheme comes in, default position is you have done a provision within the contract as per the Act's provision, and if you fail to, the scheme provided everything, who on what day the due dates are, on what date the final payment dates are, by which date you have to submit your notices, and what's going to be the content of the notices. Everything is spelled out in the scheme. It's a very nice, easy, readable documents. I don't know why people think it's a very complex one. I always found it very easy and interesting, because if you have the construction background, it's not going to confuse you at all. Or of course, you have to have a legal background as well, because I've seen people having construction background are reading so many things within it which is not there. It's a simple act, it's a simple scheme. We're talking about responsibilities to pay, responsibilities to issue notices. Any failure, you are bound to pay if the other party, the aggrieved party, takes the route for your default. As simple as that. Now, if the notified sum is not paid, an aggrieved party may adjudicate. No need to send anything that this is the dispute which is crystallizing. No, no, not needed at all. If either under the contract or under the scheme, a notice was to be given because there is a payment in issue under the contract and the payer failed to issue the notice, or their agents failed to pay the notice, issue the notice, and the payee has given either a notice in default validly, including the sum specified and the basis on which it's been calculated, or because the contract permitted an application to be made by the contractor, the payee in the normal case, and just he did that validly. So that becomes the default notice and the payer has to pay. Exception only if he has validly made um, a, a notice of intention to pay less than the notified sum within the prescribed period. Prescribed period is, the act is not saying anything as a default. The parties have the choice to agree, but if the parties do not agree, then the scheme will come forward to help us, and that's again the business of the scheme. That's all about the background. If there's a failure, you have a chance to go and adjudicate, right? And what I'll try to show you here, that's the intention, is a draft of a referral. I'll not touch on the notice of intention to adjudicate today. In the next part, I will do the same for, not for a payment adjudication or a smash and grab or payment technicalities, but on a claim for an extension of time and liquidated damages. And I'll actually combine these two, obviously, and just to make it a bit more interesting. And I will show you a draft today. You know, this is a live one. This has been submitted to me earlier by a party. And of course, I've redacted, I've changed the names and things. And the next one also I'll be showing you a live one. And obviously, if you want more information, how to respond or what are the issues here and there, you can always come back to me. Just to assure, I will send a copy to Julie of that draft. So Julie will have the draft referral notice. And if you want a copy of that, you're always most welcome to send her an email. So let me go to my draft, okay? That's the draft referral notice. I just minimize it a bit more so that, okay. This is the first page of a standard referral notice document. And I'm not saying this is a must style. It's a matter of style for you, but it's not a pleading. So no one can say you have to include these nonsensical paragraphs at the top, no matter you like it or not. It's not like that. That is coming from CPC or something, but it's quite common a practice that if you are making a claim, it's best that you identify under a statute, you best that you identified the statute and the scheme or a rule under which you're making your claims. That's one requirement. So what I do always when I act for a party and I suggest, and I see as an adjudicator, because I mostly act as an adjudicator, that all the parties do it. They first identify the top head that in the matter of the Housing Grants Construction and Regeneration Act 1996, as amended by the Local Democracy Economic Development, there should have been a space there, Economic Development and Construction Act 2009. So that's the basis. That's, I said at the beginning of the slides, that this is a creation of a statute, and this is the statute I've referred to as the title section, if you may want to call it. Then, of course, this is also in the matter of the Scheme for Construction Contract England and Wales Regulations 1998, as amended by the Scheme for Construction Contracts England and Wales. Again, there should have been space. Regulations 1998, Amendment England Regulation 2011. So that's That's what's the procedural rule contained into the scheme, which is applicable as a default position. Now, one thing I sometimes see, I don't know why people are confused about that, but I would like to take an opportunity to explain that to you, that people sometimes write it down that this adjudication is under the contract. Now, if there's no harm, it's a possibility, rather than this next paragraph, it could be in the matter of a contract for providing construction services at such and such place, the site, it could be, but it would only be as such if the contract provides a procedure. Okay, contracts provides a procedure. Or, for example, you are not actually adjudicating under the scheme, you're adjudicating under an act complied scheme. Let's say CLC adjudication. Then you replace this. Other than that, it's this, either because it's default or such as JCT contract says, the adjudications in every adjudication under the contract, section clause 9.2 of the conditions of the contract says, every adjudication under the contract will be under the scheme. So you don't then say that my adjudication is under the contract. You still say that my adjudication is under the scheme as agreed by the parties. Okay, so options are either an act compliant scheme procedure, or a contract, or the scheme. Only three. And whichever one is working for you, or is that under the contract, you just specify that. And in the matter of an adjudication, of course, to let everyone know that this is an adjudication between, of course, blah blah construction services limited, I in short call them XX, double X is not too bad, and then of course the X building services limited, which is 1X. And this is to remind everybody that this is a referral notice, and of course the date. And I prefer to actually add, if it's under the scheme, in the footnote. I didn't give it to you because some people do not like it, but if it's an adjudication under this scheme, in all my decisions I do this. On the day one, when I start writing the decision after receiving the referral and accepting the term, accepting it and notifying it that I have accepted the submission, what I do is I put on the footnote the date, which is the date of receiving the referral is day 0. So 28 days to be counted from the next day. And then the adjudication decision due by. It keeps everyone under notice that you have 28 days time. I do it, I haven't added it here because I've seen many people, or most of the people who are acting as party representative do not include. But if I were to write my own one, I've actually adopted it from someone else, so I haven't added that there, but I will always do that. So come to the next page. It's again a shorter version of the heading, and then referral. I always tell the parties a summary to everybody because it helps. If you can, you don't have to write down your summary at the beginning. Once you complete your document, please let the other parties, be it the adjudicator or the responding party, that this is what in summary you are going to discuss. So what it is, X as the referring party in the adjudication gave X, the responding party, a notice of intention to refer a dispute under a construction contract on such and such date. Of course, this will be done later. That's why I've put it in this will be done later. It's only a draft exercise. Real time, you will know when you did that. Regarding X's failure to assess and pay excess XX, the notified sum under the contract. So this dispute is a payment adjudication dispute. This is you're alleging that the XX has failed, X has failed XX to pay the notified sum. You see, it straightway kind of allows people to understand what we are talking about. It doesn't waste anyone's time, and it saves a lot of time. And if it saves time, it saves cost and money as well. I don't like to write a lot because I'm not an Englishman, so I might not be able to even. So I like to be very short and precise. Then the next thing, following on from here, XX claimed that it issued a final account application under the contract for a gross sum of such and such on, there's a typo here when I was typing, I don't know, under the contract, on sum of etho on dot 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 days, and then under the contract. The word ER is not correct, ASR is not correct, it's under the contract. I will correct it before I send it to Julie. So the dispute was crystallized on, I've just picked up a date for nothing, but just a date, when the contract administrator of X first failed to assess the entitlement, did not issue a payment notice within the 5 days of the due dates. The final date of payment was such and such. Any payless notice under the contract must have been issued 5 days before the contract, but an alleged payless notice was issued only 2 days before the final date of payment. Excess applied to the appropriate nominating body and received a notification of nomination. Again, that will be done later on. I can't give you now today. Today on such and such, if the day you issue the notice within 7 days under the act, you have to send a referral notice. So you say that today, this is the date, and this is the 7th day or the 5th day or the 3rd day or the 1st day or whatever of the notice. You might be surprised, how can there be on the first day a referral notice from the date of notice. It really happened to me this year once. I was in a series of adjudications. On the third adjudication, the referring party made an application, sent the notice, and then attached it, sent it to the RICS president that they are looking for an adjudicator. And because it's a series, it's preferred that I'm going to be appointed, and I was appointed in the afternoon by the president, and referring party straightway has submitted. So within the same day it happened. So that's why I'm not saying that it's the 7th day or the 5th day or the 3rd day. On the contrary, I've received a jurisdictional challenge on this year only. For the first time in my life, I've seen this, that a notice of referral should be sent 7 days after the date of notice, but it was being sent only after 3 days, and it's invalid. God bless. So, that's what you state, and that's it. Okay. Now, details of excess claim. First, the parties. Well, the referring party, if it's a company number, registered address, office, blah blah. Okay. Responding party, the name, if it's a company limited, the usual things, and who were they, and things like that. And representing such and such, that if you are the representative, then say that I've been instructed to represent for this referral, issuing this referral notice. And if you know the name of the representative of the responding party, don't say he's this representative. Jesus, as per the last communication, he was, because it could very well be. Right now I'm sitting as an adjudicator in a dispute where the earlier lawyer has been changed when a notice has been issued. So don't always assume that is the case. Now, then you come to describe the contract. These are all there. I've discussed it many a times earlier as well, that A appointed B or X appointed X as a contractor through the order dated such and such, and the contract required just a briefly few lines, to carry out all these things. The contract was for a lump sum amount of such and such, and it included a provisional sum, and adjusted contract value was after deducting the provisional sum and the instructions being made and all these. So that's the final adjusted sum of the contract. Contract was an amended JCT SBC. Just pick up on this word. I will refer back to it. when I come to the next episode, it's not a clear JCT SBC XQ, it's an amended version with contractor's design portion. That's not relevant for you. Just it's there. But take a note on the word amended, because we'll later see that it will be helpful. Now, contract name such and such as the architect and the such and such as the quantity surveyor. Now, dispute, the background and crystallization. Due to various these things, change instructions, blah, blah, expend provisional sum, delay in responding, blah, blah. The project was delayed enormously. Eventually, excess achieved practical completion of the works on, let's say, 4th May 2021. And the CA on such and such issued a termination notice despite excess achieved a practical completion. So after practical completion, a delayed practical completion, and the contract administrator has just issued a termination notice. Then the contractor is saying XX issued a final application on such and such day. The due date was 5 days from the date of the application, and the final date of payment was such many days from the due date, and X should have issued a pay less notice 5 days before the final date of payment. None of the notices came within time. Accordingly, X is entitled to that. So it's not, see, it's not saying us whether a payment notice was issued or not, but it's saying notices came within time. Accordingly, X is entitled to the notified sum and interest on the unpaid sum. So that's the detail of the claim. It's always good to provide the adjudication provision, since it's the JCT. I've just picked up those and stated that. And then again, the details of the notice of intention to adjudicate, breaches and the entitlement of the notified sum. Briefly again repeat that such and such date I made a final application. Net sum claimed was this under the application. The contract is now terminated, and accordingly the net sum includes the sum, actually the whole of the retention money now, because it's terminated. And XX asserts that its claim of such and such is the correct value of the entitlement under the contract. XX originally planned to claim a sum that was slightly different. However, XX revised its claim to accommodate the comments of X where possible. XX also claimed a lower sum where there was option to do so. Also claims in this adjudication interest on the outstanding sum of its claim from the date X failed to assess the claim sums correctly. SS suffered and is entitled to the notified sum of this much interest. The interest conclusion is just shown below. I've used some real figures, although it's just, I have used, see, this is the sum which is outstanding, okay, as per the claim. This is not what at all you have to be worried about. Now, this is the date from which it was outstanding, okay? Just put down the current date. So how many days is this? This many days. So interest rate is, I'm saying, see this 2% is amended. So 2% and 0.10 is the, not 0.1% is the Bank of England rate during this period. So the total is 2.10. So the product of the daily product becomes this. So this multiplied by 254 days will become this. Always have an Excel where you create this so you will never go wrong. These are the things you need to know, and it's described here. Based on this above, this is the calculation. Adjudicators' fees and expenses. You can say that, why it is attempt to negotiate and settle the claim. However, X failed to take any appropriate measure to engage and settle the matter. Accordingly, X has no other choice to rely on the formal dispute resolution, but to rely on the process under the contract. X is assessed that X is responsible for the entire fees and expenses of the adjudicator for the decision. Then the redress sought, and then the evidences. Everything done. That's all, and I'm done for today as well.
Okay, thank you very much, Mohammed. And as Mohammed said, if you would like a copy of that, or if you have any questions for him, please feel free to either email me and request, or if you have any questions, to email Mohammed. Okay, if you do have questions, now is the time to ask. Either Q&A or chat panel, chat tool in the bottom panel there. Please feel free to send your questions over. Otherwise, as Mohammed said, he is indeed back next week, our stalwart of the seminar program currently. So thank you, Mohammed. We have construction, sorry, we have I Want My Money Getting Paid, which is next Wednesday with Mo at 8 a.m. And then in the evening, next Wednesday, we have insurance and the JCT contract, Wednesday the 24th, 6 p.m. And that is with John Sharp. And then our last seminar for the year will indeed be Mo, bringing up the rear there bravely in December the 2nd, 6 p.m. Thursday, will be the last in the Adjudication Matters series, claiming time and money in adjudication, as Mo's referenced earlier. So if you'd like to book a place on any of those, please email me seminars@silverllp.com and I will be happy to send you the login details. Okay, it looks like that's it for the evening, Mohammed. Thank you very much for your time as always. Thank you everyone for joining us, and we look forward to seeing you online again very soon.
Bye-bye.